this, and I don't think either should be removed. I think they should both be retained. And it's because they both serve as protections for the tenants if there is a grievance, or as you're saying, if somebody doesn't buy the milk on time. So I think your interpretation of this becoming a civil matter first and really not going to regulatory services is appropriate. And that's also why the notarized statement is there, is so that the administrative law judge or the mediator, whoever's dealing with that encounter, has something to go back to. Democratic governance is not well defined. It's very intentionally broadly defined. And the essence of it is mutual agreement. And cooperatives face this when we go to administrative law judges around conflicts that have fractured the cooperative membership. And often what the judge does is makes a vote occur between all the members to decide how to resolve the dispute, and that's the decision. So I think a lot of the disputes, if they did ever occur, they would have a pathway for the grievance to go through some judicial arm or through mediation without ever coming back to regulatory services. I think some of the concern that you're addressing is about interpretation of the language about the considerations. And as I read them, and I hope this is how regulatory services reads them, is that these are things that may be considered. Not all of them would have to be in place. So for instance, I could have my driver's license at that address, but end up filing my taxes at a different address, maybe my parents' address for some reason. And if you look at the language, I think you might see that there's some ability for some flexibility there, which then gives regulatory services the ability to say, no, you're trying to avoid accountability internally, and so this doesn't seem right. But we made the laundry list of all the different things that they could consider so that they could see what to embrace, because these communities are very diverse. They come in all shapes and sizes, and it's really about the mutual agreement of what the people living there want to do. And I guess the final thing I would like to say is I hope you pass this today and that you forward it to the City Council and then evaluate the results of it. There are a few dozen of these communities now. We may have a few dozen more that end up popping up out of the woodwork again because they're operating in secret. And then we can evaluate what of this works, what doesn't, how do we trim it back. And in the next cycle, we can look at things like density and occupancy and other issues that really go beyond the scope of this.
Did you have a question?
I have a couple questions.
Would you be willing to yield
Sure.
for a question? You do
not
not
fine.
have to.
Absolutely.
Okay.
I'm sorry, I forgot your name, sir. Mr.
Tom Pearson.
Mr.
Pearson.
Tom Pearson.
Yeah.
Mr. Pearson, thank you. I really appreciate you coming and articulating and clarifying a lot of these items. So if you had two options in front of you, and one of them was to simply allow all of these intentional communities that are presently existing to continue existing and allow others to commence, that's one option. And then the other option is to implement all of these additional restrictions. Which would you prefer?
Today, I'm coming to you as a representative of the coalition.
I understand
So
that,
I would
yeah.
prefer that you pass this as is.
If I were to ask you, without your representative of the coalition hat on?
Well, it just seems that the other thing you're proposing may not actually pass the council. And I would rather have something
So that's a good point.
this
So,
year
yeah.
rather than nothing for several years.
So I entirely understand what you're saying. So this I'm hoping I agree with you. Actually, I don't know whether it would or not, but so at the end of the day, really, this is more of a controversial / political question than it is a policy one.
Right.
And I appreciate your candor.
Thanks.
I'll wait to make my other points.
Okay, we'll take Charlotte next.
All right. Hi, my name is Charlotte Calanti. Thank you for hearing me. And I guess for me, the stakes of this ordinance passing are really about cooperative development in the city of Minneapolis. I myself live in the Students Cooperative, which is an intentional community of about 30 people, 30 students on University Avenue. And I can talk about my personal experiences of it being very empowering to be like 1/29th of a homeowner in college, and how for me it's really important to have a say over the rules I live by. But more than that, this is about like affordability for people who are shut out of homeownership and who are shut out of mainstream economic institutions, like students who have a lot of debt, and also historically co-ops have been there for marginalized groups, whether through racial discrimination or age discrimination, as a tool for homeownership and as a tool for neighborhood stability and stopping gentrification. So when we talk about how we're going to address those problems in Minneapolis, I don't think you can talk about that without talking about this ordinance and about talking about how these kind of intentional communities create co-ops. And so that's really important to me for you to understand. And I think it's in line also with the Aging in Place initiative that Minneapolis wants to promote, in the fact that older people living together, maybe like 5 unrelated older people living together, like that's an intentional community. And if you want this city to be friendly for older folks, then that's really necessary. And for older people to have a say over the way their living conditions are. I don't really think I need to extol the benefits of cooperatives. I think that they're pretty, evident. The UN has talked about it. The city of Minneapolis itself has designated like the first week of September as co-op week. So for me, it's like, if you don't want this to be empty lip service or kind of tokenization, then you actually need to pass laws that are going to promote cooperatives. And the reason, Councilmember Reich, I remember you asking this question in the beginning, why isn't this ordinance just about making an exemption for co-ops? And the reason for that is that a lot of cooperatives don't have the wherewithal to just up and start and incorporate. It kind of develops out of more nebulous collectivist structures where people are living together in houses and then come to the realization that they can be homeowners and that they can promote economic justice and neighborhood stability. So for me, those are really the stakes of this. And I just to echo what Tom was saying, passing this now is going to really change a lot of people's lives. Like, I know the Students Cooperative will start another co-op for older students if this passes. If this doesn't pass and we wait for 3 years, it's just like, what's the point? I don't know. This can happen, and I think your fears are real, Councilmember Frye. But I also think they seem small compared to the potentials for cooperative growth and economic justice in this city. Thank you.
Joseph? I'm sorry, Joseph. I'm terrible with my glasses are terrible. Joseph Walls? Okay, sorry. You don't have to, but you're welcome to.
Sure. Yeah, I organized a group of intentional communities, a network over Facebook, and this is one of the number one issues for them. I have operated one and now 2 intentional communities, and both of them legal, both of them within the zoning, but most of them have this issue. And so this is a very real issue for a lot of them. A lot of them would like help in doing this because they're doing a lot of good work in the community as far as making housing affordable, which is, I know, one of the issues that you guys have been talking about. And so this is a tool in the tool belt of putting in the hands of the people of Minneapolis to potentially create affordable housing for themselves. Also create, for a lot of people, it's an issue of wanting to be more communal, and not, our society is very individualistic. And so it's just one of those things that I think would be good for the community as a whole, having groups of people living together in a responsible way. And I think that's why we've applied some of the things, is to make it a very responsible way to do so. Actually, Mr. Grumpy's been to my house, and I'm actually doing something a lot of intentional communities can't attempt to do, and that is go the legal route of creating individual kitchens, bathrooms on each floor. And so it's been a year and a half of my life, and it's been very expensive to the point that it's drained almost all my financial resources, all because I want to live in this way that I find very enriching. And there's a lot of cities that don't have these restrictions as well. San Francisco, Seattle, for instance. So it is worth having a good conversation maybe about zoning, because that's the primary issue at hand, is the zoning issue. So, and I'm happy to ask any questions about intentional communities as being a caretaker of one.
Sounds like there aren't any questions, but thank you for being here today and for your testimony. And it's just Troy here. Someone please step forward and state your name and address for the record.
Troy Benjicurtis, 2508 17th Avenue South, Minneapolis. And I didn't quite realize I thought this would be a really simple thing. And then I realized this issue is extremely political. And I think if you really tried to make the perfect thing, you're going to have something worse than the last election. Just because, so some of my background is where I grew up, the biggest business was a farmers cooperative. But then I went to a small city, Ames, Iowa, and the biggest business was a rental property. And there was one guy, one family, one real estate tycoon that owned most of the rental property in Ames, Iowa. And it kind of irritated me. And the other thing I also saw at the same time was between Ankeny and Des Moines, I saw all of the world's best farmland getting turned into cookie cutter housing developments because it was profitable. And so what I ended up doing was I bought 2 homes in Ames, and I decided to start an intentional community. And I've had limited success with that because it's hard to find the kind of community in a smaller town like that. And second of all, there's this issue of this sort of arbitrary. You can't have 3 people who aren't a family, more than 3 people who aren't a family living together. What I ended up doing is in those 2 houses now I have a intentional community lease that says I have one house right now. I have 2 tenants, and they each have a lease where they pay a portion of the rent, and they get a room, and they get shared use of the rest of the space, and they can decide. I don't really care how they decide, but I try to find, part of me for my financial benefit when I look at what's going to be a good investment, what's going to maintain the property values, and that's really what it is. This is about property values. And who gets to take advantage of the increase in that value? This is really important. Who gets to take advantage of the increase in the property values? Because the vision that I really want to see is I want to see hundreds of cooperatives on Minnesota equity crowdfunding portals where people in the community are investing in their neighbors' ability to own their property, to own their future. That's what I really want to see, but that's a really kind of a long thing. And I think it's sort of like what this is maybe is a consensus but imperfect step towards that direction. Then I have a whole bunch of other stuff, but it's about property values, because I think the reason we have these limits of, well, we can only have a family of, or you have to have no more than 3 unrelated people, is because people want to protect their property values. And when all of a sudden, when a high density development comes in next to your residential house, your property values go down. And that's part of the rationale about why do you want to have something. Whether or not you can enforce it is an entirely, this is a whole nother can of worms. But we don't say anything right now if a family is, the head of household of a family is a little off his rocker and is, whatever. There are other things. There's civil law. There's other laws that take care of that. And it's I can see that there's a potential that there's something to work through. That's why we have the rules that are written in there about what this is. But I guess to me, really what I see, Mr. Frey, what I think this will look like is we're going to have a lot of equity crowd-funded cooperatives that are going to start revitalizing neighborhoods and cleaning up places, because these people they're there, they're invested. They're not just somebody who's paying a rent check every month and are going to move on to the next newest, nicer building as soon as this one gets sold. They're going to be invested in maintaining the neighborhood. They're going to be invested in paying their property taxes. They're going to be invested, and they're going to be politically active.
So can you sum it up?
What's that?
Are you done?
Yeah, I think so. So I guess the other part of this is I've lived in an intentional community. I've tried to start one, and I've kind of had a halfway successful doing it. So I've got some experience, and the fact that one of the things right now is there are intentional communities in this city that are afraid to say anything. They are afraid of retribution, and I don't have that problem because I am the place that I have still fits under that 3-person.
Great. Thank you for your testimony.
Thank you.
Is there anyone else here to speak to this issue? Oh, please step forward, state your name and address for the record. And we did get about a dozen comments that were submitted to the public record that were put on the city's drive for council members to look at as well. Please state your name and address for the record.
Yep, my name's Kyle Cuppy, address 2000 Sharon Avenue Southeast, apartment 33, Minneapolis, Minnesota. I'd just like to step back. So obviously I highly recommend that the committee approves this, the intentional community ordinance, and here's why. With my situation, I've been looking for a house to buy and actually partner with a ministry that's near the U of M. I've been looking between Dinkytown and Marcy Home. And out of the last 4.5 years that I've done research and actually looked at homes, 52 of the homes are technically illegal in how they're doing it based on the zones and stuff like that. One of the things that I found in July 2016, there's a house, the address is 705 12th Avenue Southeast, that I'm actually looking at buying. And I'm looking to close on it come early next spring. And so this house, when it was built in 1926, 24 nuns used to live here. It was owned by the Catholic faith and whatnot. Currently today, it's an R2B zone, which can only have 3 people, but the house is 7,000 square foot. So it's a huge house. I do believe that 18 people could live here, and based on this ordinance and how I'm looking at it, so like to Mr. Fry's comments on number 5, how I look at that is like that's a single family home that they have shared expenses, things like that. Like it's all based on 1 meter type deals and things like that. For me, I'd actually live there. I'd be the sole owner. I'm a very hands-on person. I'd actually look at partnering with a ministry called Chi Alpha to help fill the house and actually bring this property back to what it was built for, which was building community and growing the ministry. Those are my kind of 2 cents on it. I don't know if you guys have questions on that or if maybe that applies better to a situation.
Well, I guess I would say if you're in an R2B, you could have 2 units, each with up to 4 unrelated people, plus an ADU. So you could have more than 3.
But how this house is set up, it's actually a single family home, so there aren't multiple units.
Then what someone else said really applies, because then you'd be forced to put in a separate kitchen. You'd be forced to put in separate metering of electricity, which is a huge expense to be able to live the way you want. So
Right.
thank you for your testimony.
Thank you.
Is there anyone else here to speak to this issue? Anyone? Anyone? Seeing none, I'm going to close the public hearing. Councilmember Fry?
Thank you, Madam Chair. So every single one of the benefits that the individuals that spoke have extolled are accurate, I agree with, and can be accomplished by increasing the occupancy limits to allow the intentional communities to exist. When we talk about affordable housing, this accomplishes it. When we talk about allowing intentional communities that are pre-existing to continue, this accomplishes it. When we talk about intentional communities' ability to expand, that accomplishes it as well. I was actually over, I'm sorry, ma'am, I forgot your name. Charlotte. I was actually over at your house a few years ago, 3 or 4 years. I had a ball. And I would strongly encourage you to open another one. I think it's a spectacular setup there. I'm for it. I just don't agree that this is the way to allow you to do it. I want you to be able to practice what you're doing now. I think it works. I think it's an excellent way to build community, to help for affordable housing. You name it. I believe in the communal experience. I just believe in the communal experience without a substantial amount of government interference. And I feel like items 1 through 5 especially, and I have a question about D1, but it's specifically C1 through 5. If we're not going to get involved in these areas, and it sounds like we're not, let's not have them in the ordinance. You just testified a second ago that, well, these things are going to be considered, but let's be honest, we really don't want to insist, we don't want to enforce the fact that this individual is registered to vote at this particular location. And we don't want to enforce the matter of that this particular individual has a license, a driver's license that says this particular address. If we're not going to do it, let's not put it in the ordinance. I feel strongly about
Fry,
this.
I'm going to move approval. So if
Okay.
you do not want me to move approval and you want to postpone this to continue to work on it, Councilmember Gordon and I have worked on it to death. You can do that. I'm not going to amend it on the floor. We're not going to change occupancy here today or in the next cycle.
Well,
So, and I actually think I, as one of the co-authors, basically required us to go out and have some large public hearings and encourage people to come. And the reason there wasn't a lot of objection is because it was written the way it was. So any changes you make, I likely would not agree to, because I don't think that holds faith with the communities that we asked to come together. Those are just things you want. And so I think it's important that we get something through for the people who have been living under this cloud, where we can make what they're doing legal, take a look at how it works for a year, and then make changes if need be. That would be how I would look at it. If you want to do something different, let me know what you want to do differently, and we can vote on that.
Well, Madam Chair, what I would prefer to do is amend on the floor, but since that's not something you're looking for, I'm perfectly happy to go back and do the work necessary. I think items 1 through 5 should be eliminated, and that's what I would amend to do. So I would move to, I'm not moving, but what I would like to do is move to eliminate items 1 through 5, and I actually have a question about D1.
Well, I mean, we can sit here till 5 o'clock at night looking at this. We have 6 more items on the agenda, including 3 public hearing items, of which most people seem comfortable with this except for you. So if you want to amend this, then you should either move it forward without recommendation or postpone it a cycle to work with Councilmember Gordon's office on some of these issues.
I'm gonna move it forward without recommendation. I will move. You've already got a motion on the
Nope,
floor.
I said I would defer.
Okay, so I will move this without recommendation, with the hope of amending specifically items C1 through 5 and D1.
Councilmember Gordon, can you speak to whether or not there'd be any willingness to do that? Because if not, we might as well pass it as it is today.
So I couldn't quite hear your specific question, Madam Chair.
Councilmember Fry would like to,
Would you be supportive of this?
wants to support gutting the language C1 through 5.
To get rid of it?
No. And if I could speak to that?
Please.
I think that we're ready to move forward on this. I just have to say that this is something that I've been looking at since 2008. And we went through a 2-year process. Every little piece that's in this ordinance is something that was kind of negotiated with the community. I know from a conceptual point, and I share that conceptual point, if it's a safe house for your cousin or your grandmother or your wife, it should be safe for your friend. But we have some very big houses in the city. We looked at that option. We actually measured houses in Southeast Como in the University neighborhood. We said for this house, if we just simply said we're going to go all on the housing maintenance code, people were saying 15, 20, 30 people allowed in the houses. Very concerned about landlords and what they do with those, all of those issues. It took us a long time to kind of come to this spot right now where I don't have the opposition of a single neighborhood association in the city of Minneapolis. And I could easily have written an ordinance or just lifted the occupancy and we'd have the room packed with people worried about it. You're probably right. I'm probably right. It's probably we're over concerned about our zoning code and the occupancy limits. But I don't think the city of Minneapolis is ready. I'm not sure that we'd get a majority of votes for that anyway. And I don't know if it's smart to do it right away because we could end up having such a big backlash. We'd end up never getting intentional communities like this set up so that we could actually address some of these serious concerns that are going on right now that we've heard about. This is also something that's called out specifically in our plan for aging in place. The term intentional communities came up in their plan, and they want to do this. So did accessory dwelling units. And accessory dwelling units is getting at this from a little different side. So this is intentional communities. And it's another piece of that. This would be a good, actually, I think if you want to just 5 years or down the road, whatever, look at opening it wide open. For those of you who might want to do that, and I'm not for my constituents back in the second ward who are concerned about that, that's not my secret master plan, but it might be a good test for us to say, can these intentional communities work with these guidelines and regulations? And if they are, maybe we'll say, now's the time to take away some guidelines or regulations. We actually got a lot of pressure from a lot of different directions. A lot of people are still concerned about just letting one rental property do this. We heard from people who said, just do it like the accessory dwelling units where you have to be owner occupied. but we also heard from a lot of people who want to do it. There's no way they could afford a house, but they want an opportunity to do this. So we hammered out that compromise. Well, what if it's just one rental property owner that can do this? I mean, one property that a landlord might own as their rental property in their portfolio can do this, and also that they have to be in the proper tier where they're good performing according to our standards. So I just want to encourage the committee, and thanks for giving me all this time, and I could probably talk more about it because there's other issues that this gets at. I guess I just want to hit the one last one that's come up a couple times. We have seen house after house in the area also get chopped up, and the integrity of our historic homes is being destroyed because people are putting in kitchens and making duplexes and triplexes where they probably don't necessarily belong, and they don't even want them. And I think this is a way to get at that too. But I think it makes total sense for us to move forward with this thoughtful approach, this compromise, and see how it works. So I'm hoping that we won't end up postponing it.
Councilmember Fry, followed by Councilmember Reich.
So, what I see here is that we're getting residents of the city of Minneapolis comfortable with an ordinance by including regulations that we've explicitly said we're not going to enforce. So the way I see it is it's in name only. We've said we're only going to be, this is what it says in the ordinance itself. It says that shall be considered in determining whether a group operates as intentional community includes, and then it lists stuff. So we're going to consider whether to have these things. We might not. Hopefully we wouldn't be enforcing these things. Maybe we would. Laws matter and words matter, and we should be clear about this. So I 100% support the goal. The mechanism in getting to that goal, I don't think is clear. I think it's ambiguous, and it's not entirely honest, especially if we're not going to be enforcing these pieces. And with regard to old historic homes being cut up, items 1 through 5 have nothing to do with that.
So Councilmember Fry, do you want to make a motion to eliminate those?
I do.
We'll vote on that, and then we can move forward. Go ahead.
I move to amend the ordinance to eliminate items 1 through 5, and then I'll have questions about D1 for later.
Okay, on Councilmember Fry's motion to eliminate items 1 through 5, all in favor signify by saying aye.
Aye.
Any opposed? Nay. That fails. Next.
I have a question about item D1.
Okay, maybe we'll. Why don't you ask the
in the
question?
interest of respecting everybody's time, I'm gonna I'll ask staff offline.
I can't. Which section is that? I'm sorry, I can't find. Oh, D. Okay.
D1. It's fine. I can ask staff
Prohibiting them
offline.
to be a rooming house.
Yeah, you might want to ask it because I think Councilmember Gordon knows the answer.
It says a dwelling unit in which the various occupants act as separate roomers may not be deemed to be occupied as an intentional community. The question is, what does acting as separate roomers mean?
Councilmember Gordon.
Well, and I think that our reg services folks are well aware of that. Is that's when everybody has a separate lease, they pay their rent separately, they come in and they go as individuals. It's essentially a rooming house.
It's not an intentional community because they're not working collectively on ownership or taxes or any of those things. That is by definition a rooming house. That's what we're trying to avoid. Okay, so.
I have no amendment then.
Okay. I'm going to move approval of the item number 17 in its entirety with the staff recommendation. Are there further comments or questions? Councilmember Reich.
Thank you, Madam Chair, and I'll be brief. Obviously, I know this was a lot of work in the making. I've already been sort of outed in terms of my initial intentions about expanding the cooperative enterprises in the community. Obviously, this is a kind of a compromise step. I think Charlotte's commentary about this being a gateway or a stepping stone to that. Obviously, down the road, I'm going to probably press to maybe make that intention in the intentional communities ordinance more explicit. Through mechanisms of partnerships with our cooperative networks out there. I think to be helpful in that intention is to get to that end more swiftly, if not more fully. I think because this is a public hearing, I think all statements are public domain. So if there's anyone forming a band out there that wants a cool name, Nebulous Collective Structures, I think is a great candidate for that. So that's out there for public consumption. And so with that, I think, the way I looked at this when I was having conversations in my backyard, if I had my druthers, we would be expanding the cooperative framework even more aggressively. However, I do believe in this stepping stone thing. I think we can maybe refine that moving forward after we kind of cast this out for a year or two. Also, there's the downside. There's the fear. People say you regulate things because not when they go right, or you have this great sort of vision of how we're going to utopically become the super cooperative city of Minneapolis. What happens when they go wrong? What happens when it's, for lack of a better term, a flop house? When people are flouting rules, or this is a great loophole to create all kinds of inappropriate living situations or negatively impactful situations for the broader neighborhood or that block. A lot of times rules are about what can go wrong. I think we have a lot of little tripwires in here for when things do go wrong. I'd be very surprised that we wouldn't pursue things if there's a complaint. We often are pretty reactive to a complaint given system. And I imagine the department would absolutely be looking to see that all the T's are crossed and the I's dotted. And if there are flouters, I'm assuming that flouters don't always follow the rules well, and we'd have them. And I would like to have those tripwires for those who are seeing this as a loophole and not an opportunity. So is it perfect? That's for time to tell. Thank you, Madam Chair.
Further comments or questions? Seeing none on the motion to approve as originally submitted, all in favor signify by saying aye.
Aye.
Any opposed? No. That item is approved. We're then going to move on to our quasi-judicial public hearings. I'll note that that is items 18 and 19 as well as item 30. So I'd like to just get a check from the committee about their opinion about the two discussion items. Should we hold staff here longer for that? Because we want to discuss them. These are both, the ESG grants is a good news item, and the infill housing work group are recommendations that potentially we could take up at a future date. Who's here on that? Is it possible we could take up the infill housing work group recommendations in January or not possible?
I think that would be possible.
Yes. And I'll defer to Councilmember Yang and note you are very nice to be here. This has been a long meeting and people are kind of on the tired side, and I'm a little concerned that we're not going to have a fulsome discussion about this important work where you've really made a difference in trying to figure out the future of Green Homes North. So I wonder if we shouldn't take it up when the meeting isn't as long, because we have 3 quasi-judicials right now.
Thank you, Madam Chair. I would be fine with us postponing this for another time. And I do have to say that there were many other Ward 5 related matters that I was here for. So thank you very much.
Okay, so with the committee's feedback, and feel free to give feedback, I'd like to move item 28 and postpone item 29 one cycle, and that would also trigger Ways and Means postponing one cycle also. Is that okay with the Chair of Ways and Means? Is that okay with the committee with regard to direction moving forward today? Okay, so we have dispensed of the, oh no, I'm sorry. First, we will take up item number 28 for an actual vote. Are you upset? No. Okay. I see Mikkel here and all the good work he does. I feel bad. I'm just going to move the staff recommendations with regard to the ESG fund recommendations. There was a written report in your packet and online, and it's very consistent with what has been happening over the past few years. So on the motion to approve item 28, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. And on item 28, I'm going to move to postpone one cycle. All in favor signify by saying aye. Any opposed? That was item 29. And then I'm going to turn the chair over to Councilmember Fry for items 18, 19, and 30.
Thank you, Matt. Thank you, Madam Chair. We have it's 18, 19, 20, and I believe 30 as well.
20 has been, I'm sorry, sir, 20 has been postponed to January 3rd also.
But 30?
January 3rd, number 20.
So we have numbers 18 and 19. The first is a motor vehicle repair garage license for Ahmed doing business as Ahmed Certified Auto Care, 616 45th Avenue North. Here to present is Mr. Fussy. Mr. Fussy.
Well, I can handle this. This is a matter, it was a business license denial recommendation from business licensing, and it was submitted to our municipal hearing officer who drafted a findings of fact, conclusions of law, and recommendation that is before you, signed October 25th, which adopted or affirmed the staff's recommendation to deny this business license. I don't believe that the license applicant is here. He certainly has been notified of the hearing, and we would ask the committee to simply adopt the recommendations of the hearing officer after seeing if the license applicant is present and wishes to add anything.
Thank you, Mr. Fussy. Are there any questions for Mr. Fussy? Seeing none, I will open up the hearing specifically for the individual and/or his or her representative. This is a quasi-judicial license hearing for which this committee is limited by law to hearing argument from the owner and the owner's representative, but is prohibited from considering any further evidence or taking any further testimony. This means you are required to limit your comments to arguments specifically addressing the evidence or testimony introduced before the hearing officer, which is part of the record that is already before us. Is the individual or representative here today? Are they here today? Individual representative here? Seeing they are not, I agree with Mr. Fuss, with staff's recommendation, and I will move to approve that recommendation. Any further comment? Seeing none, all those in favor, please say aye. Aye. All those opposed say no. And that item passes. Item number 19 is a rental dwelling license revocation for 3032/3034 Cedar Avenue, which is Cedric Thompson, considering revocation of the license. And here to present is Mr. Magrino.
Good afternoon, Mr. Chair, Mr. Vice Chair, and committee members. I'm Nick Magrino from Regulatory Services. The property involved in this action is 3032/3034 Cedar Avenue, a triplex. The respondent in this matter, Cedric Thompson, is the owner of record and obtained a license to operate this property as a rental business in August of 2006. On August 12, 2015, housing inspections conducted a routine rental licensing inspection at the property. The inspection resulted in a notice of ordinance code violations ordering corrections in all 3 units for violations like repairing interior surfaces, providing smoke and carbon monoxide detectors, plumbing fixtures to code, and providing fire extinguishers. Notices were sent to Mr. Thompson's address at 1341 Case Avenue in St. Paul. In October, November, and December of 2015, Mr. Thompson requested 4 separate reschedules of his re-inspections for those violations, and on December 3rd, 2015, a re-inspection of the property occurred and some of the initial violations were corrected, but additional violations were discovered, and an additional violation notice was issued to the owner, including obtaining permits for the fire doors that had been installed at the property. A reinspection of the property occurred on January 27, 2016, and several of the violations had not been corrected. A reinspection of the property was scheduled for March 25, 2016, but was rescheduled by the owner for March 28, 2016. On March 28, 2016, the owner did not appear for the inspection. A reinspection letter was sent to the owner setting an inspection for April 28, 2016, and on April 28, 2016, the owner again failed to appear at the property to allow the inspection to occur. On May 18, 2016, Housing Inspections issued a Notice of Director's Determination of Noncompliance to Cedric Thompson, notifying the owner that the property was in violation of MCO 244-1910 or licensing standards, and specifically Standard 8, failure of the licensee to allow required inspections. The owner was given 10 days to come into compliance by allowing the required inspection. A copy of the Notice of Director's Determination of Noncompliance was also sent to the resident of 3032 Cedar Avenue, Unit 3. We received no communication from the owner after the issuance of the Director's Determination of Noncompliance, and on July 12, 2016, a Notice of Revocation, Denial, Non-Renewal, or Suspension of rental license or provisional license was sent to Cedric Thompson at the listed address of 1341 Case Avenue in St. Paul. Notice of the pending revocation was also posted on the rental property located at 3034 Cedar Avenue, and Mr. Thompson was given 15 days to file an appeal requesting an evidentiary hearing on the matter, and no such appeal was filed. So the city is requesting revocation of the license, and at this time, I'd be happy to answer any questions that you may have about this.
Thank you, Mr. Magrino. Are there any questions for staff? Seeing none, thank you. I will open the hearing for the individual licensee and/or the representative. Are they here today? Are they here today? Seeing that they are not here today, Mr. Magrino made good points, and I will move to adopt the staff recommendation. Are there any further comments on this topic? Seeing none, all those in approval, please say aye. Aye. All those opposed, say no. And seeing that we've handled items 20 and 30, I'll hand it back to Chair Goodman.
No, 30.
30 we still have to take. Final item is number 30, which is a rental dwelling license denial for 5420 44th Avenue South. And here to present is also Mr. Magrino.
Mr. Chair, I'll take the opportunity to present this one and I'll be as brief as possible. This matter once again involves very frequent litigant Margaret Capix in his ongoing appeal to the Minnesota Court of Appeals challenging the council's September 2nd denial of his application for a rental dwelling license at 5420 44th Avenue South. As this committee likely recalls, last cycle the Court of Appeals ordered you to consider his motion to proceed in forma pauperis, which you denied. The present matter has also been referred to this committee by the Court of Appeals pursuant to an order directing the City Council to consider Mr. Capek's motion for a stay of the denial of his application for a rental dwelling license at the property. Mr. Capek has been notified of this afternoon's hearings and should be afforded a very brief opportunity to address the committee regarding his motion. Initially, I would note, just for the record, that city staff would request that you deny his motion based on the following three factors. First, the motion for a stay is not procedurally proper because there is no action to stay, since the underlying matter was a denial of an application for a license which does not exist, and it was not the revocation of an existing license. Hence, there's really nothing to stay here. If there was an existing rental license that was being revoked, that revocation could be stayed while the appellate court considered the appeal. But this case involves a mere denial of an application for a license, and at no time has that license existed. Second, the legal standard for considering a request for a stay pending appellate review involves balancing the appellant's desire to maintain the status quo pending appeal against the public's interest in enforcing its decision. However, in this case, the status quo is actually maintained by denying the stay request. Again, because this involves a license denial and not a revocation, the status quo remains intact because there was no rental license at the property before the application or appeal, and there would be no rental license at the property during the pendency of the appeal. Third and finally, Mr. Capek's appeal of his rental license denial at the property is plainly frivolous and has been much of his related litigation filed in state court, federal court, and the appellate courts. As the council record reflects, the license denial was based on the indisputable fact that he had a separate rental license revoked on another property at 3324 23rd Avenue South in 2015 for illegal occupancy and other inspections violations. Based on that revocation, he is clearly ineligible pursuant to Code of Ordinance Section 244, 1910, 13B, which holds that a landlord who has had a license previously revoked may not obtain any new rental licenses for 3 years. That separate rental license revocation was also appealed by Mr. Capek to the Court of Appeals and was dismissed by that court in its file number A15-1541. Therefore, his ineligibility to obtain rental licensure this year at 5420 44th Avenue property is clearly established and supported by law, and its appeal is frivolous. Based on these reasons, staff would request that you deny his present motion for a stay after you would see if Mr. Capek, who has been notified of this hearing, is present.
Thank you, Mr. Fussy. Are there any questions for staff? Seeing none, I will open the hearing to Mr. Capek and or his representative, and seeing that the room is totally empty with the exception of Mr. Magrino, I won't ask a second or third time, and I'll close the hearing. And I'll move the staff recommendation for very reasonable and thoughtful reasons. Any further comment on this topic? Seeing none, all those in favor, please say aye.
Aye.
Aye. All those opposed say no. That item passes, and seeing that we have no further items on the quasi-judicial agenda and the CDRS agenda, we are adjourned.